personal records are defined. You can't just say, poof, this is a personal record.
That's where I want to get to. Yes.
But again, that was Peter Navarro. That was not Donald Trump. And so there's still this argument over, well, what if the president says it's a personal record?
Welcome to Law and Chaos. Today, we're joined by national security law expert Kel McClanahan to discuss the Trump documents case in Florida and how Judge Eileen Cannon is going to blow it up. Kel is uniquely qualified to talk about the multiple fights over classified documents that make up the heart of this prosecution, and we both agree that while the judge has played this case more or less by the book so far, she's done it in such a way that it allowed Trump to waste months of time and make it unlikely that this case will go to trial before the election. We've got a lot to cover, so let's get after it. Hey guys, it's Liz Dye. Obviously, the big news this week is that the Supreme Court has functionally taken the Trump election interference case off the docket, ensuring that it will not be heard before the election. I wish there was another way to look at this, but that is the universe we live in. At least 4 justices voted to grant certiorari on the issue of Trump's claim of magical, everlasting presidential immunity. He says that it was part of his official job to disrupt Congress and try to get Mike Pence to reject the swing state electors, functionally tossing out 20 million swing state votes. That's ridiculous on its face. Congress is a separate branch of government from the executive. Trump had no duties with respect to the certification of the electoral vote. But Trump went even further than that and argued that a former president could never be prosecuted for something that was part of his official duties, or perhaps maybe if he was first impeached by the House and convicted in the Senate. But other than that, no. This led to a memorable colloquy during oral arguments at the D.C. Circuit in which Judge Florence Pan cornered Trump's lawyer John Sauer and said basically, look, the president's duties as commander-in-chief put him in charge of the armed forces, and by your logic, the president could send SEAL Team 6 to assassinate his political rival, and unless he was impeached and convicted, he could never be prosecuted. So, look, that's a pretty stark illustration of the problem with Trump's argument. And in fact, no one has ever contemplated the kind of immunity Trump argues is, clear as day. You could go all the way back to the Federalist Papers, or you could think about Ford pardoning Nixon and Nixon accepting that pardon, because everybody understood that a former president could be prosecuted for crimes in office. The White House counsel's office told Bill Clinton that when he was president. So I'm going to say that I don't think the Supreme Court, like even this Supreme Court, I don't think that they're going to rule that Trump is right, that this, magical immunity thing is a real law. First of all, it would immunize Biden and every Democrat who came after him for prosecution after office. But second of all, these justices had a lot of chances to help Trump when he was in office. And at the end of the day, they opted to kind of let him delay instead. I mean, they eventually ruled against him, but by then it was more or less not important. So here's how that shook out. When the Democrats took back the House in 2018, they launched all these investigations of Trump and they subpoenaed his financial records. At the same time, the Manhattan District Attorney, who was at the time Cyrus Vance, was investigating Trump in the predecessor to the New York indictment that's been brought by Alvin Bragg. Trump sued the district attorney, that was Vance, and he sued the House Ways and Means Committee, and he also sued Mazars, who was his accountant, to stop anybody from looking at his finances, right? He didn't want Mazars to turn them over to the prosecutors. He didn't want them to give them to Democrats in Congress, and he filed this lawsuit. And the Supreme Court took the cases, and they allowed Trump to wring like 8 months of delay out of the process. Eventually, they ruled correctly that a sitting president is not immune to criminal investigation or civil process. And, at the end, Mazars handed that stuff over and the House got what it was looking for and the DA got to investigate. But I don't think, looking at that this court, even this court, is going to rule that presidents have absolute immunity forever. But I think, as they did before, the justices will, and pretty clearly already have, drag this out long enough that there's not time for them to rule and allow the case to go to trial before the election. They've given Trump the delay that is his ultimate goal. So they've scheduled oral argument for April 22, which is fast. But even if they sent the case back in June, there's still like 3 months of pretrial stuff that has to take place at the district court before the case can even begin, to impanel a juror. And the trial itself is supposed to take 3 months. So the Supreme Court's decision to weigh in here is in fact a decision to put this case off until after the election. And that means that if Trump wins, he can end the whole thing by pardoning himself or firing special counsel Jack Smith and, locking him up or something. That's it. That's the end of the story, which is horrible. And look, I'm going to lay it out. You're not going to like where this is going because Trump has filed an identical immunity motion in the documents case in the Southern District of Florida. I mean, it's not identical because he claims that he can't be prosecuted because he was president at the time he purloined all of those classified documents and stuck them in his, pants pocket and that when he walked out of the White House, he was still president and he had authority to do it. And he'll claim he's declassified them at the time and because he had that power, which is stupid. That's not how any of this works. You don't declassify stuff with your mind. He's suggested that he had a standing order that when he took classified documents or even, government documents to the personal residence in the White House, that automatically, transubstantiated them into unclassified public documents. That's stupid. That's not how any of this works. And he's kind of stopped saying that since the judges in D.C. who are overseeing this case forced people in his administration to testify and overrode their claims of executive privilege. So they all had to kind of say under oath, no, there was no standing order. That's dumb. So he's kind of stopped saying that. But when he makes this immunity claim in the Southern District of Florida, it is likely to automatically shut down the trial while he appeals it. And, look, the Supreme Court is already on that claim from D.C. and they're not going to even hear it until April. So I think it's a virtual certainty that Trump is going to run the same play in Florida that he ran in D.C. And in D.C. it worked. So for Trump, a delay is as good as a win. And so, look, he plans to get back in the White House and blow up all of these prosecutions. And he knows that if he doesn't, he's probably going to spend the rest of his life in jail. So he wants to hold off until after the trial. Keep all that in mind when we talk to Kel about the Florida case. Trump's one and only goal is to chew up the clock here, and his lawyers are going to file 100 gonzo motions demanding not just to see government secrets, but to put them on the public docket. And they don't really care about whether they get to see this stuff. They don't really care about whether it's public. The only reason they're making these dumb arguments is to kind of make themselves ungovernable and extract delay, right? Because if the government has to fight them and say, no, we're not putting the national security secrets on the public docket as evidence, that's not a thing, then it wastes time. All right, before we get to that, quick reminder, we will be doing our first ever live Q&A on the Law and Chaos YouTube channel with the help of Stephen Robinson, my buddy, aka the Playtyper guy. That's March 7th, 8 p.m. Eastern Time. If you're around, you'll be able to watch the show live. And if you're a subscriber through patreon.com/lawandchaospod or on Substack at lawandchaospod.com, we're going to put up a special column or link where you can ask us questions to answer live on air. Or you can submit them to us via email at lawandchaospod@gmail.com and then tell us your subscriber handle so, we'll know it's you. If you have questions about topics we're covering, quirky law stuff, even if you want to know a little more about me, reach out and we'll try and get through as many as we can. And if you support the show, you will also get the high-quality audio posted after the broadcast to listen to at your convenience. We're really excited to try this out. Maybe we'll do it more regularly. And, of course, thank you guys so much for turning out to support the show as we get our podcast legs under us. Whether you're a casual listener, a devoted fan, a financial supporter, I appreciate all of you, and I couldn't do it without you. One more thing. Kel and I recorded the show around 3 on Thursday, after which Trump and the special counsel each filed motions in advance of tomorrow's hearing, today as you're listening to it. They suggested when they think the trial ought to be scheduled since, look, everybody knows the May 24 date is off the docket. The prosecutors would like to begin on July 8th. So not that much delay, like 7 weeks. Trump would like this trial to begin never. So he opened his brief by saying, As the leading candidate in the 2024 election, President Trump strongly asserts that a fair trial cannot be conducted this year in a manner consistent with the Constitution, which affords President Trump a Sixth Amendment right to be president and to participate in these proceedings, as well as, inter alia, a First Amendment right that he shares with the American people to engage in campaign speech. So basically, he's saying making him show up in court like a criminal defendant stifles his First Amendment speech because he has to go out and be on the campaign trail, which is that's some privilege right there. He also made a bunch of noise about Biden witch hunting him. And so, it's impossible for him to go to trial before the election, and that the court should just take the trial date off the docket altogether. But he tried this back in 2023 when he asked Judge Cannon to docket this for never, and she said no. So Trump did, in fact, submit a calendar to the court, blocking off every day that he cannot be there. And I hope you can hear the scare quotes. He can't be there on any day where there's a primary in any state. And his lawyers are going to be apparently taking a lot of vacation days this summer, as are the co-defendant Walt Nauta and Carlos de Oliveira's lawyers. And he can't show up for the RNC, and all of that is apparently more important than a criminal trial. So the date that he says that he could first be in court is September 6th. We're going to see how that one lands tomorrow. And with that, let's take a brief ad break, and we will be right back with our interview with Kel. And we're back. With us today is Kel McClanahan, the Executive Director of National Security Counselors, a Washington area nonprofit public interest law firm which specializes in national security law and information and privacy law. He's an adjunct professor at the George Washington University Law School, where he teaches the law of secrecy. Kel, thank you so much for being with us.
Well, thank you for having me.
Let's start off by saying, what is CIPA?
So CIPA is the Classified Information Procedures Act. It is something that came out of a problem that came out many decades ago, where you would have people who had access to classified information being arrested for crimes, for whatever they were being arrested for, and they would do what was called gray mail. It's not exactly blackmail because it was technically legal. They would say, I work at the CIA, and if you prosecute me for child pornography or hit and run or whatever, then it sure would be a shame that I would have to reveal all of the classified information I know when I'm put on the stand to defend myself as the Constitution guarantees. And so Congress grappled with this and set up these procedures that would allow courts to basically balance the need for a constitutional jury trial or constitutional prosecution with the need to protect national security and classified information.
Cool. And that was in 1980.
Yeah. And there's a whole bunch of CIPA. There's really only 5 parts that really matter. And there's sections 2, 3, 4, 5, and 6. And it just runs down very quickly, section 2, and there's a little mnemonic that I'll give you and your listeners to sort of understand where I'm going with this, is what I call the heads up. That is just, you're going to notify the court if there is going to be an issue down the road, saying, hey, judge, heads up, there will be classified information issues somewhere in this case. Let's start the ball rolling on that. That's really simple. Either side can do that. Then you have the fight that we had a few months ago, which is section 3, which is shut up. That's the protective order, that the government comes in and says, I need a protective order to keep the defendant from disclosing classified information that we give him. And the judge shall enter a protective order. Now, they don't have to always enter the protective order the government asks for, but they have to enter a protective order. And that was what the fight was with in the Trump case in Florida about 3 or 4 months ago.
Right. Just to be clear, there was classified evidence and, that was going to have to be turned over in discovery. And the special counsel said, hey, Judge Cannon, can you please enter a protective order on this? And she, as I recall, screwed around for a bit, but she did it.
She did. And she entered 2 different orders. She entered one for Trump and one for Nauta and de Oliveira. because their cases were different, and we can get to sort of how that plays out later. But former President Trump's case was all about the classified information. And so he had a need to see a lot more classified information than the other two who were just being charged with obstruction of justice. And so that's why there were two different orders in that place.
Right.
And then you got to where we have been for the last few months, which was Section 4, which is what I call the cover-up phase. It's basically the government comes in, generally ex parte, and tells the judge, okay, we would otherwise legally be required to turn over the following classified information in discovery, and we don't want to. We want your permission to basically treat it as if it doesn't exist, or to redact documents, or to substitute documents, or what have you. It is generally the government's show. There is limited utility for the defense, although that's what the big fights have been over, where President Trump's defense team wanted to get involved in this. And that's where we have been for the last few months. In the future, after we get done with all this, then the government will turn over whatever it turns over. It finishes discovery, and then it'll go to the defendant side, to Trump, to do Section 5, which is where he speaks up and says, okay, here's all the classified information that I want to use in my defense. And that is the first time that he actually has to do anything. And that's not going to be a good day for him, but that's in the future. Then you get to Section 6, which is the final section for the most part, as far as we're concerned, which is where the stand-up. That's where both parties go to a trial and have a hearing and argue over everything in Section 5.
Got it.
We're not there yet, though. We're still just finishing up Section 4.
Okay. So let's talk about what happened in Section 4, because this has been, to my mind, unduly contentious.
Right. And I'll take it a brief aside to say there's not a complete lack of merit in the complaints that were made by Trump or Nauta or De Oliveira or literally anyone else who is a defendant in a SEPA case, because the court is sort of hamstrung by the statute. And while they do have discretion, the point of the law really, really favors the government. And they put in this standard that says the judge has to evaluate whether the information that the government wants to hold back and not turn over in discovery is helpful. It's relevant and helpful. And relevant is something that everybody deals with. That's a normal discovery argument. Helpful is this unique thing in SEPA, where basically the judge has to act as though they are the lawyer for the defendant. And would I, if I were defending the defendant here, think that this would help me without informed input from the defendant's lawyer? Now, they do get to have their own ex parte hearings for the most part and say, here's what our legal theory is, but it is very one-sided, and it really does put the defense at a major disadvantage.
Okay, so let me see if I understand what you're saying. It looks to me like we are at the stage where the government has to make a showing of the classified evidence it does not wish to turn over to Trump and to his co-defendants. There has not been a determination yet,
Correct.
But they got hung up starting back in November because, remember, there, as you said, there are two classes of defendants. There's Donald Trump, who allegedly stole all of these classified documents, 102 documents bearing classification markings, which were found in the August of 2022 raid on Mar-a-Lago, and Nauta and De Oliveira, who are accused of lying about their efforts to first move the documents around to evade detection, move the boxes of documents around, and then later to erase the tape of them doing it, the security footage of them doing it. So they've made two different claims here. Nauta and De Oliveira made this maximalist claim that they needed to see all of the classified evidence, despite the fact that they're like, they're his body men, they're his valets, and I think maybe De Oliveira is like a gardener or something. And Trump has said, I get to see all of the classified evidence. And so even before we got to the petition to withhold the evidence under Section 4, the government's petition, we had an argument about who was going to be able to see this Section 4 petition to withhold the evidence. And Nauta and De Oliveira said, we get to see the whole petition because, we're involved in this case and we get to see all the evidence. And the government said, well, you tell me what the government said.
So the government made a series of arguments. The key argument that works for the government in this case is sort of twofold. And it's number one, every other case where this has come up has said ex parte is just fine. They have not found
ex parte means outside the presence of the client, just between the judge and one side.
Just between the judge and the prosecutor. That many defense lawyers have tried this in the past, and it's never, ever, ever worked. So there is that to be said. So the first part is that it's never happened before. And the second part is that if you think about the purpose of Section 4, the idea is this is keeping information from the defense lawyers. Mm-hmm. And involving the defense lawyers in an argument over whether or not specific information can be kept from them lets the cat out of the bag and gives them the information that the government is trying not to give them.
Right. I'm trying to explain to the judge why this particular piece of classified information should not be handed over. And if you get to see my argument about why this specific piece of classified information shouldn't be handed over to you, you've functionally seen the piece of information.
Right. You may not have a copy of the document, but you know what it is.
Right.
Now, in some cases, this is not as important if it's something that, for instance, the defendant already knows, where you're just trying to avoid handing over the actual document, but the defendant knows what's in it. In other cases, it's where the defendant has no idea what you're doing. It's a good example would be in FISA. This happens a lot if the reason that the government got clued into some illegal activity was a FISA warrant.
That's a Foreign Intelligence Surveillance Act.
Foreign Intelligence Surveillance Act. Mm-hmm. They do not want the defendant to know that there is a FISA warrant or what it's for or what was collected through it.
Right.
And so that's where you're operating you're counting on the ignorance of the defendant of what you're talking about. Mm-hmm. This was a mix of the two. If you assume, which is not always a safe assumption, that Donald Trump paid attention to everything that he read and that he knew what was in these boxes, mm-hmm. then you would say, well, what is the point of giving it to him if he already knows what's in it? And the argument is, well, because he has the document in his possession now. It's the same reason that there are exceptions to what's called the prior official disclosure rule in FOIA for telling somebody something versus giving them a copy of the record because there's plausible deniability. If Donald Trump goes out and says, I was told XYZ, the CIA can say, but he could be lying. If he goes out and says, here's the document,
right,
then that's a lot harder to deny.
Right. I mean, I think, look, there's a colorable argument that, of course, Trump knows what's in these boxes. These are the boxes full of stuff which he deliberately did not give back to the government,
right?
Which he hid from his own lawyer, not to get too deeply into the weeds. But you know who doesn't know what these documents are, one would assume, would be Nauta and De Oliveira.
Right. And that comes around to Nauta and De Oliveira, where what is in the documents is not relevant to De Oliveira. It doesn't even matter if it's helpful. You can do the De Oliveira and Nauta argument without even getting to helpfulness because they're being charged with obstructing justice. They're being charged with moving boxes that contained classified records of some type. Mm-hmm. And it does not matter what those classified records were. It only matters that they were classified, that they were national defense information.
Right. To defend themselves against the charge that they lied to the grand jury and to the FBI and that they tried to delete the footage. They don't need to know what was inside those boxes.
Right. They would be equally liable if they hid an NSA lunch menu or a secret war plan for Egypt. it doesn't matter what the document is. They hid it and they tried to obstruct justice and they tried to destroy the videotape footage. So that's the relevance. And even though criminal relevance is generally weighed very heavily in favor of the defendant, that's where helpfulness comes in, where you say, okay, even if it was relevant, even if you are entitled to see the information you are alleged to have moved, knowing this would not help you. There is no argument you can make. And they made lots of arguments in the abstract, which Judge Cannon sort of called them out for, of how it's very important that they know information so that they can defend themselves. And the end ruling that she came down was, no, there's nothing you can say legally that would change the fact that knowing this specific information that was in these documents does not prove whether or not you tried to destroy videotapes. And it does not prove whether or not you moved boxes that you were told had classified information in them.
Right. I don't even think it matters whether they were told the documents had classified information in them. I think that's kind of even more essential to the ruling, that she said, basically, you lied about moving the boxes. What's in the boxes at all, classified or otherwise, is not germane. You lied, and then you tried to hide the evidence that you'd lied.
A good analogy would be, let's say that you're being accused of hit and run. You don't need to know what the victim of your hit and run did for a living or where he ate dinner.
Right.
It may be relevant. It will not be helpful.
Right. So that was her ruling, that she said, basically, you guys aren't getting the classified information. Right. You don't need to see it. It's fine. But she had a different ruling with respect to Trump.
Because in Trump's case, it's clearly helpful and it's clearly relevant. Now, the difference there is that we haven't gotten yet to whether or not the government can withhold the information. We've gotten only to whether or not Trump's lawyers can be involved in the argument over whether or not they can withhold the information.
Right. That's that Section 4 filing.
And that was basically a First Amendment and a Sixth Amendment challenge against SEPA, Section 4, and against the ex parte procedures, where they said you cannot expect a defense counsel to surrender their decision-making authority over what's helpful to a judge. You cannot expect us, even when we do talk to you about our legal theories, to be able to anticipate everything that could happen if we got all this information. We deserve this information. And the government, for its part, overplayed their hands a little bit. They got a bit of a bench slap from Cannon, and honestly, I think they deserved it, because they came out and took the position that no, she could, even though, yes, technically the statute does say may, you really don't have any discretion in this, because oh my God, national security. And it has to be ex parte because, oh my God, it has to be ex parte. Look at all this. It is clearly ex parte. And she said, no, it's not. It's I have discretion. I am choosing not to exercise it here because I agree that in this particular case, the need for the defendant for this information to be helpful does not outweigh the need for national security. But slow your roll there a minute. I still have that discretion.
I'm going to push back a little bit on you. And look, obviously you're the expert in this area, but my understanding of this argument was that Trump pointed to the plain language of the statute. And I would agree with you. The plain language of the statute says this hearing may be held ex parte. This application process to withhold the evidence from the defendant may be held ex parte. But every court has ruled that it shall be held ex parte, because otherwise it would defeat the entire purpose of the law to say, hey, here's this whole explanation of why we can't share this with the defendant. And then, by the way, I have to share this with the defendant. And so in her ruling, it appeared to me that Judge Cannon said, you guys are jerks. This is what the law means according to me. But according to the 11th Circuit, i.e. the people above me, that's not the interpretation of the law in the 11th Circuit. And so, fine, I have to follow the 11th Circuit.
There is a bit of that. I mean, I won't deny that there was very much, I am bound by precedent, no matter how much I may not like it,
right?
To her opinion. But there was a certain degree of merit to her position.
I mean, let's be fair. You're always on this side. You're always the one trying to kick loose the information. That is your actual job.
Yeah.
So that's your institutional bias. I mean, I hate Judge Cannon, so there we are.
This is something that comes up, and it came up in Trump's argument over the January 6th committee trying to get his records,
Right.
where there are cases where statutes say may, but the government acts as though the Congress didn't really mean may. It meant may in the rare instance that the smoking gun is misclassified by a Nazi infiltrator. And that's never going to happen. So it's a de facto shall. And yes, it says may. And I mentioned the J6 committee. So this is what happened with Trump's argument over his executive privilege in those records. For people who may not remember this 20 gazillion years ago, the January 6th committee tried to get records from NARA that were from the National Archives that were about from Trump's presidency, and Trump sued to stop them, saying it was executive privilege. Mm-hmm. And he did that without the blessing of the current executive, the White House. And he pointed to the fact that, look, the PRA, the Presidential Records Act, says that if the archivist decides to override a claim of executive privilege by a former president, it shall hold on to that for 30 days to give the president a chance to challenge that. Mm-hmm. And people came out and said, well, look, that means that there's a way to challenge it. And other people like me said, no, that just means that they were giving him a chance to try and pull a rabbit out of a hat to find some way to challenge this. But at the time that statute was written, nobody had any question that there was not a situation that would meet the criteria for challenging that. And that's what happened here. Your argument is, and the government's argument is, no one has ever succeeded in challenging this. And Cannon said, that doesn't mean it can't be challenged, but I will agree that nobody has succeeded yet. And according to, as you say, the 11th Circuit and every other circuit to have dealt with this, I can't either, because the test that they have set out is not met in this case. But I'm going to stick a pin in that and say that in the future, I may find that this is that extreme circumstance that warrants a deviation from the ex parte process. And she did that at the end, where she just held on. If something new comes up, we can try this again.
Right. Okay. Let's put a pin in that for 1 second. I'm going to take an ad break, and then we're going to come back, because I know we want to talk about the PRA, but we're not quite done with this part. Yeah. So, okay, 1 sec. We will be right back after this ad break. Okay, we are back. Let's finish up talking about SEPA before we move on to the PRA, to the Presidential Records Act. What is going to happen next in the Trump docs case?
Well, now that we have finally decided who can actually make the arguments, the arguments have already been made. Honestly, she had the hearings with the government. She even had hearings with defense lawyers, with both for Nauta and De Oliveira and for Trump, talking about what is your theory of the case? What do you need here? She has not ruled on the actual Section 4 motions by the government yet. That is what's next. How long she takes for that, who knows? She's already heard the arguments, and so probably if I were to sort of try and look into a crystal ball here and say what's going to happen next, I would say that she probably held back on really diving into the weeds on the Section 4 hearings with the government in case she might find that the defendant needed to be there so that she wouldn't have to go and retread all this territory again. Now that she has decided that the defendant's lawyers do not need to be there, I think she'll probably have another hearing ex parte with the government. I know that I would if I were her. Let them just lay everything on the table, question the hell out of them, and then reach a decision probably in the following weeks. We don't know how many documents they're talking about, how many redactions or what have you.
right, just to be clear, we're talking not only about the 102 documents which were seized from Mar-a-Lago, we're talking about all of the evidence turned over in discovery or that should be turned over in discovery, which is classified. And there will be some of that, right?
Right. And that includes Jinx Act stuff. That includes Brady stuff. That includes, anything that he has asked for
Right, that's
relevant.
exculpatory evidence that has to be turned over
Yeah.
pursuant to the law. Yeah.
Right. And so because he was the president and because these were highly classified documents and he would be within his rights to ask for information about the provenance of these documents and who classified it and why was it classified, all of that is relevant information that he would be able to ask for, then we don't really know how long that'll take. This could be tens of thousands of documents. It could be as little as 1,000.
Right. And let's just talk about this because we've been screwing around with this dispute for what appears to me to be a long time. I don't know the timelines that these usually take, but I know that they've been making this argument about the ex parte nature of the Section 4 filing since like November.
Yeah.
And the deadlines in this have already been adjourned. As far as I can tell, this case is functionally off the calendar for, I think it's like May 24th is when it's scheduled. I don't think that's really going to happen. Most people don't think it's going to happen. Most people think that Judge Cannon is functionally squatting on the calendar kind of as a stopgap in case the Supreme Court sent the DC election interference case back in time that it could get back on the calendar and Judge Chutkan could schedule it. But since that's not going to happen, thanks to what happened yesterday in SCOTUS, it looks to me like she's now free to kind of get off the calendar and move the case forward. But she's effectively allowed Trump and his co-defendants to chew the clock for 4 months, screwing around on this, kind of pre-Section 4 issue.
Yeah. And I will say, 4 months is not long in a SEPA case. There have been cases that do not get a jury trial because of SEPA stuff for a couple of years. Because every step of the way, there's a Section 7 I didn't get into. Every single step of the way where the judge has the ability to rule against the government, if she does, the government gets an interlocutory appeal immediately. Now, whether or not they take it is another question, but they get it. And this is sort of Jack Smith's show where he could cut short a lot of these deadlines by giving a lot of classified information to Trump. It's one of those things of his lawyers do have clearances. They were processed for clearances as part of Section 3 and Section 2. They have access to a lot of classified information. The only stuff that the government is going to really probably be fighting to hold on to, knowing that the clock is running, is probably the super duper sensitive intelligence sources and methods stuff. Like turning over the actual Egyptian war plan as opposed to saying there is an Egyptian war plan or there is a war plan for another country or something like that. And so if he can narrow the documents that he's trying to withhold down to a very manageable number, then Cannon doesn't have a whole lot of air cover for taking a long time to think about it.
Oh, interesting. Let's move on to the Presidential Records Act because Trump has filed a motion to dismiss with respect to the Presidential Records Act. And I really want to talk about this. Look, because these are all kind of related, right? We're talking about classified documents and who owns the documents, whether they're personal or presidential. And make to me the argument that he's making in this motion to dismiss, as you understand it, because I think it's pretty nebulous.
So this is another one of those cases where you kind of have to call out the government for hypocrisy, for talking out of both sides of its mouth.
Do you?
This is one of those things where Trump's motion basically piggybacks on the Hur report about Biden's classified information that came out a couple weeks ago, where there was an entire chapter in the Hur report, chapter 10, that talked about how presidents for decades have taken home records that contain classified information, and the DOJ knew about it, and the White House knew about it, and nobody cared. And with the best example was the Reagan diaries, that Reagan kept extensive diaries. They contained classified information. He took them home as personal records, and people tried to sue to get access to them, and the DOJ defended against giving them away, acknowledging that they contained classified information, and yet they were still President Reagan's personal records, and he was free to do with them as he saw fit because the PRA. And
okay. Well, all right. I mean, that's kind. I know what you're getting at, but okay.
And so the argument made by Trump is, look, they're singling me out. This is sort of almost a selective prosecution argument.
He's making that one too.
There's this long-standing practice and this long-standing understanding by presidents that they can take home personal records that have classified information. It's not entirely applicable to him for a few reasons. And the key reason it's not really applicable to him is that under the PRA, even if you accept that this is something that the PRA allows, which I do not accept, and some judges have been sort of reticent about accepting, you have to designate something a personal record when you create it. And so when I start writing in a diary, dear diary, my first day as president was awesome. I invaded Egypt. I say, this is a personal record. I don't get to 5 years later when someone raided my house to get that diary say, but wait, that was a personal record.
Okay. Let me interrupt you here, because I think that there's two things, and you understand them and I understand them, but I just want to make sure that everybody understands. We're talking about two separate things, right? That there were, as you said, there's this record of presidents taking home their personal diaries, and those are personal records. And everybody understood them as personal records from their inception. And that's the infamous Clinton socks case, where Clinton stored these tapes of himself talking in the sock drawer. And then after he left office, Judicial Watch sued the National Archives and said, go get those records. Those are presidential records, not personal records. And the court said, we don't have the authority to go tell NARA to go do anything, so get lost. And from which Trump and his minions have inferred that there is no authority for NARA to go seek any records purloined by ex-presidents.
So hit pause on that, because the Sox case was a bit more nuanced than that.
Yes.
Surprise, surprise, it was more nuanced than Trump is letting on and Judicial Watch is letting on.
Yeah.
But it did help Trump a little bit, because the judge in that case sort of tried to carve a middle ground. And she said, even if NARA has the authority to go get this, I don't have the authority to order them to. Mm-hmm. And so that's the first part. But then she later says, and the PRA does say that it's up to the president, so maybe they don't have the authority.
Yes. There was some dicta in that case by Judge Amy Berman Jackson.
Yeah, Amy Berman Jackson. And that part is the part that everybody's sort of seizing on. But fast forward to last week, when Judge Coarcatelli just said in Peter Navarro's case, personal records are defined. You can't just say, poof, this is a personal record.
That's where I want to get to. Yes. Agreed.
But again, that was Peter Navarro. That was not Donald Trump. And so there's still this argument over, well, what if the president says it's a personal record? I think, for instance, that if President Biden today gets a briefing from the CIA,
yes,
and it is about a secret spy mission, and he really likes this and he wants to take it home, he can say, this is now a personal record. He can arguably take that home and then be sued later to get it if the archivist disagrees that it was a personal record. But there's nothing per se preventing him from converting an agency record into a personal record.
Okay, but wait, here's the thing that I think is getting sloppy here in Trump's, deliberately sloppy in Trump's probably inadvertently constantly sloppy pleadings, right? Is that we're talking about two classes of documents here. We're talking about general government documents and we're talking about classified documents. And Trump has made this maximalist claim without actually making it, that he declared, like I declare bankruptcy, like in the office, right? I declare this document a personal record, whether it is classified or whether it is whichever agency has created it. He has kind of yada, yada, yada over how these documents went from being classified documents or government documents, government property, to personal and unclassified documents living in the pool shed at Mar-a-Lago. And his lawyers in the brief where they said this case should be dismissed because the Presidential Records Act empowers Trump or the president to magically transform all of these documents. They haven't said he did it. right? They haven't said he declassified these documents. They haven't said he even declared bankruptcy, declared personal, declared unclassified. They just said it happened. We don't know when. We're pretty sure it happened. Or they've said it happened by implication, because when he sticks them in the bottom of his pants and walks out of the White House,
it's personal.
It's personal. It's declassified by implication.
Yeah.
Because his lawyers did not want to put in a filing, which they put their names on, an attestation that he had declassified or transmogrified these documents into personal records.
Right.
And that's where the slippage is.
And it's I want to say that this is a deliberate.
You want to say it's deliberate. It's deliberate. I'll say it's deliberate. It's bullshit. It's deliberate.
It's totally a deliberate choice, but it's playing on sort of smushing together two different arguments in order to make the argument. The first argument is he has the right to make personal records. The statute says he has the right to declare things personal records. Mm-hmm. The implication, like, what rational human being would stick an agency record down his pants, is a silly argument, but that's the argument we're making. So let's set that aside and say, let's assume that he declared these to be personal records. Mm-hmm. Well, the next step they have to hurdle they have to overcome is, but you're still responsible under the Espionage Act for the classified information therein.
Right.
And that's where they go and pull up practice. That's where they say he's allowed to make personal records. And, oh, look at all these other presidents that took home personal records that had classified information in them. Mm-hmm. And so they're sort of smushing those two things together to say he has an absolute right to take home personal records that have classified information because no one's ever been prosecuted for that before. Mm-hmm. And it's a weak argument. It's not completely toothless. It is weak at the juncture points between the arguments, where they have sort of fault lines between the arguments, so you can say, look, even if that was the case, you still have the ability to say this isn't a personal record and second guess him. And even if you don't, the fact that we did not prosecute the 5 jaywalkers before you doesn't mean that you get off on jaywalking when you shot somebody when you were jaywalking.
Right. And you know what? I want to double back to that Judge Collar-Catelli argument a second, because I actually think that's really important. Just to give some background, Peter Navarro was this like lunatic econ guy who actually, Jared Kushner literally found this guy. He was in the Amazon section looking for somebody who said, like, China trade war, this is a great idea. And the only person he found was this like weirdo professor in California named Peter Navarro. And that is how Peter Navarro became like an essential part of the Trump administration.
All the best come from California.
Yeah, trade wars are good and easy to win, and that was what Trump wanted. Okay, so when he left the White House, Peter Navarro took a bunch of stuff with him, but most importantly, he had these emails hidden on his encrypted Proton Mail account, which he refused to turn over. And Judge Collar-Catelli said, turn that shit over. And he said no, because turning it over would be an admission that I took it and I don't have to admit it. And then he said no. But what happened was the government sued him under what's called a Raplevin action. It's a civil, like, give my shit back action, which we all learned about in law school and then immediately forgot about once we passed the bar. And so Peter Navarro said, this isn't how you get stuff back. You just have to keep asking nicely, which is coincidentally the same argument that Trump is making, that there is no enforcement mechanism under the Presidential Records Act. And so NARA just had to keep asking me to give this stuff back. And if I didn't give it back, they were shit out of luck. And Judge Collar-Catelli said, no, the PRA may not have a built-in enforcement mechanism, but that's kind of implied. If the PRA says this is government property, the government has an implied right to come and get it. And that is where there is that little bit of tension with the prior ruling by Judge Amy Berman Jackson in the Sox case, where she said, well, I don't know, it's not clear whether NARA can come and get it. And here, Judge Collar-Catelli said in the Navarro case, yes, obviously the government can come and get their shit back. You can't just keep it and say, well, there's no enforcement mechanism in the law.
And the distinction, and I always hesitate to make arguments for Trump, but I have a feeling that if he has one halfway decent lawyer on his team, they're going to figure this out. So, and I don't think they listen to you. So
what?
The distinction there is the distinction that I made sort of a few minutes ago, which was you can harmonize those two. And you can say that the government has, I'm not saying that the court should do this, but a court could say the government has the ability to go and get records that someone has misclaimed as personal records, unless that person is the president. Because she was talking about the president who was named in the PRA as having the authority to do this, and Navarro was operating under sort of generic derivative authority to name things personal records.
Right.
And I think that would be a bad way to go, but that is something that a court could do to sort of try to chart a middle road.
Right. That's the crux of Trump's argument.
Yeah.
He's saying, I was the figure who could convert these into personal records, and I did. Don't ask me how or when, and please don't make me testify about it. And by the way, he's also moved that when his lawyers were forced to admit under a grant of immunity and under a waiver of attorney-client privilege, they were forced to testify in the grand jury proceedings leading up to this. They didn't seem to, we've not seen it, but it would appear that they didn't say, oh, yes, on, January 5th, he waved a magic wand over all these boxes of documents and said, I magically declassify this. I laid hands on it, used Reiki or whatever. There isn't any discrete declassification or personalization event, despite Trump's kind of long implication that there was one.
Now, you have been sort of mushing those together a lot. I want to say that deeming something a personal record versus a presidential record is different from declassifying it.
Absolutely. But I'm pushing it together because Trump has pushed it together.
Right. But that's a distinction to be made that you can arguably declare something a personal record without declassifying it. You can also obviously declassify something out without it being a personal record. And that, for instance, let's say that he declassified this information and then took it home. Would he be guilty of anything? Yes, but it would not be the Espionage Act. Unless you make a national defense information versus classified information distinction that I'm not going to make here. It would be theft of government property, but it wouldn't be the Espionage Act. This is what would happen if, for instance, like I'm a CIA employee and I have declassification authority and I declassify a record or I declassify a secure stapler, and take it home with me. I'm guilty of stealing government property, but I'm not guilty of violating the Espionage Act that I would be if I did not declassify it.
Yeah, you know what? Let's pull back just a little bit to talk. I think it might serve this discussion well to kind of talk about what the exact charges are, right? Because there are obstruction charges because he refused to comply with the subpoena and he, had his lawyers or caused his counsel to fill out a false attestation that they'd searched Mar-a-Lago when actually he'd taken all of the stuff he wanted out of the boxes before letting his lawyers search them. And that's why attorney-client privilege got waived, because he had involved his lawyer in a crime. There are some of those mishandling classified documents charges, but that's not going to get him out of the obstruction charge, right? If the PRA was somehow successful in knocking out some of these charges, it's not going to help him with the obstruction charges.
Yes and no. If it turns out that he was not required to turn the records over, then can he obstruct an attempt to get them?
Okay, let me push back on that one, because as I recollect, the subpoena was for any document bearing classification markings.
Right.
And whether he had magically, using the power of his mind, bent spoons and declassified these documents and, turned them into personal records. I'm, again, slurring the distinction because that's what Trump does. He would still have to return them in response to the subpoena. They'd still,
Or move to quash the subpoena or whatever.
Move to quash the subpoena, which is what, if you believed you had a right to do it, you'd quash the subpoena. You wouldn't lie to the government and say, I've given you everything that I've got. That's still obstructive conduct.
Right. Now, from a prosecutorial discretion angle, I'm not sure it would be a winning strategy. For if Jack Smith loses on all the Espionage Act counts get thrown out, then he's probably going to drop the case rather than move forward on a prosecution that would get him like a rap on the wrist for
right.
Trump.
We're just talking pure obstruction. I mean, although, look, he did have his guys lie to the grand jury and to the FBI, and he did tell them to go delete evidence of that lie. That's not That's not nothing. I mean, it's certainly, it's not like Obama in the tan suit. That's a real thing. But yeah, look, I think we both know, kind of, we're close to the end here. We both know it's not going to come to that. Like, one of two things is going to happen. Well, let's back up. What do you think the odds are that this case goes to trial before the election?
Okay, now that's a different question. That's not the question I thought you were going to ask me, because that goes back to the whole SEPA stuff.
Yeah.
I think that if we can get the SEPA stuff out of the way, I think it'll go to trial, because even the strongest arguments under the PRA and under all his other presidential immunity stuff. Now, the presidential immunity stuff can also delay things, because obviously, if the Supreme Court is deciding if he has immunity in one case, then Cannon's probably going to say, well, they may decide he has immunity in this case.
Let's come back in a second, because I want to talk about that. But finish your other thought.
But going back to just the PRA motion, this is one of those things that, as he has currently styled it, I don't think he can win. The only way he could win the PRA motion would be to offer some form of evidence that he designated them personal records.
And if he had it, he'd have done it.
Yeah. And if he sort of puts all his eggs in this basket of, well, of course I did, because why wouldn't I? Then that's not enough to dismiss a criminal indictment. But if he somehow pulls out a rabbit out of a hat and says, here's an order, or here's a picture of me, doing the thumbs up and over a personal record marker, then that might work. But he's going to have to do something like that. And assuming he can't do that, then this is going to trial.
Interesting. Okay. But, let's cut the shit here, because I don't think it is, and neither do you. And here's what I want to ask you about, because here's what I think just happened. As we know, Trump recently filed like a skazillion, at least 4 that appear on the public docket, and I think 3 that are still sealed, motions to dismiss this case, right? And one of them was dismiss it based on grounds of presidential immunity. And as we know, the Supreme Court has decided it's going to think about that at length and probably not rule on it until like June. And so I think what's about to happen here is that if and when Judge Cannon decides this presidential immunity thing, Trump is going to say, see, this is immediately appealable the way it was in D.C., and is going to stay the case, which is what happened in D.C. Because the issue of immunity is immediately appealable, it stayed the trial judges, anything. It stayed the entire trial. And that's why the election interference case is off the calendar. So on the off chance that this gets anywhere near happening, he's going to appeal it the same way he did the other one. What do you think?
So I think that if I were Jack Smith and I was facing down a ruling on an appeal on this, on the presidential immunity stuff, I would make the point that this is one of those instances where the differences between the cases are significantly greater than the similarities, and that that they're critical. In this case, none of the activity that he did while president was he's being charged for being a crime. They went out of their way to say, we're not saying it was illegal for him to take this out of the White House. We're not saying it was illegal for him to hold on to it for the 18 months before people found out about it. We're only saying it was illegal for him to keep it after we told him he had to turn it over. Okay, and so there is no official immunity there, because even accepting that everything he did while president was entirely legal and he's immune from prosecution for that, none of that is applicable to this case.
You can stick war plans in your pants and walk out of the White House, but if the government says give it back, you have to give it back.
Right. And after you don't give it back, then you're violating the law.
Right. And if you refuse to give it back when you're no longer the president, you don't have immunity.
And so if he loses on presidential immunity, which he probably will with Cannon, and immediately appeals it, they're going to say, you got to fast track this circuit, and he's trying to run out the clock. And there's no relationship between the two. Nothing SCOTUS will do will affect this case. and the circuit will probably fast track it just like it did the special master issue.
Okay. I have one more thing that I want to talk. We've covered so much ground, but there's one more thing I want to talk about, and it's what's going to happen tomorrow. And it's because it's a classification issue, and I got you here, and so I want to ask you about it. Because there is a motion for reconsideration regarding a motion to compel, and it's going to be discussed in court tomorrow or today as you guys are listening to it in a scheduling conference. Like about a month ago, Trump filed this motion to compel discovery because what he wants is, what he wants is delay. And the way that he's doing it is he said basically the entire federal government is part of the prosecutorial team. And so I get to kind of paw around the National Security Archives and demand that the government turn over all of these secrets because the National Archives is part of the prosecution and the White House counsel's office is part of the prosecution and probably the White House mess hall is part of the prosecution. And I get to see Dr. Joe Biden's medical history, whatever. He's demanded all kinds of crazy shit on the theory that this is all Brady discoverable material. And I read this not as like he actually wants all these national security secrets, but as a way to prolong the argument by asking for things he's not going to get. In addition to this, there is this other pending problem because when Trump has filed these motions, he's tried to put discovery material on the public docket, material which the government has handed over in discovery under protective order. And so they said, well, you can't put this stuff on the public docket. And Judge Cannon said, well, it's kind of material. And she sort of fudged it and let Trump's people kind of make a showing that they could put the stuff on the government docket, kind of shifted the onus to the government. And the government filed a motion for reconsideration and was like, hey, you know what? That's not actually the legal standard. Do you want to rethink, parentheses, you idiot? And that's where we are. We're gonna discuss both of those things at tomorrow's hearings. But because they both implicate classified and secret material, I was wondering if you had any thoughts how that was going to go.
So I'm going to push back a little bit on that. I'm not sure that it involves classified material. Because if it were, then this would be a whole different ballgame.
Well, the motion to compel does, right?
Oh, yes.
Because they want all of those national security secrets because they want to make this fight. They want to drag the fight out.
But that involves getting classified information that they don't already have. And so that is sort of the scope of discovery argument. And so they are having it ex parte, not ex parte, they are having it in camera. But I think that's more to guard against accidental spillage than anything else. I don't think that anyone is planning on discussing any classified information there.
Yeah, just in plain English, that means they're having this argument in the judge's chambers, not in open court. And accidental spillage means like somebody inadvertently refers to classified information and they don't want that to be in public.
Or they go out and they have their talking points and the judge asks them a question that they have to give classified information to answer.
Okay.
Something like that. And so unless I'm missing something, which could entirely be the case, I don't think anyone is going into that with the plans of talking about classified information because the information, he doesn't have information. The only classified information would be if he happened to know of a secret surveillance program that he wanted records from, and it was a secret surveillance program. So talking about where you want to get records from isn't necessarily classified. So I think that's fine on that point. The other part, the motion for reconsideration, I think that's more revealing witnesses and revealing
grand jury transcripts.
Stuff that generally would not be classified.
No, it's not classified. But it is protected under a protective order. And it looks to me like Judge Cannon kind of flubbed the standard pretty egregiously. And the prosecutors were like, lady, that's not the standard. Rethink. And she's like, oh, fine, I'll hold a hearing.
Yeah, and so the hearing's going to be, I would not be surprised, honestly, if the hearing itself, you saw this motion that got filed where all the media entities wanted to go and be in on the hearing. And what I would predict is going to happen is they're going to have a hearing and it's going to be, in camera. And then the judge is going to grant the government's motion and deny Trump's motion and then unseal the transcript of the hearing because nothing confidential was actually discussed.
Okay.
and grant the media motion.
All right. But what I'm really asking you is, today is the last day we're going to be able to pretend that this trial is going off in May. Like, she's going to knock this case off the calendar.
Oh, it's not going to happen in May.
I know it's not going to happen in May, but it's
no
officially still docketed in May. Tomorrow is the day when she taps out and says, oh, we just have so much to discuss here, we can't possibly go in May, right?
Yeah, this is, I have no problem saying I think it'll be done before the election, and there's no way it's happening in May. Those are two different issues.
Okay. All right, fair enough. All right. Thank you so much, Kel, for being with us. And tell us again, National Security Counselors, what's the website?
NationalSecurityLaw.org, although the website is awful, so I would not encourage anyone to go there yet.
Sell it. Sell it big. All right. Thank you so much, Kel.
No problem. Thank you for having me.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Raise Ipsa Media, LLC, all rights reserved.